topic that is so central to our very vision of the good society, and also, of course, to our professional preoccupations. The rule of law might seem to need no explication at a law school. We revere the rule of law, and that's why most of us are in the law. But some law students are probably fond of the rule of law because it means rule of lawyers. But it doesn't really mean rule of lawyers, and that's one of the things that we need to keep in mind. The rule of law is above and independent of any individual practitioners of the law. So although we're familiar with the ideal of the rule of law, it seems to me very much worthwhile to review why it is so precious to us. I think there are a number of different reasons, and some of them are more prominent in our minds than others. The first is that the rule of law is civilization's most precious heritage and our most valued gift to the future. Why is that? Well, first, it makes all other good things possible. The absence of the rule of law makes life, in the great phrase of the great philosopher of the state of nature, nasty, brutish, and short. It channels our violent propensities and political warfare into a relatively peaceful regime. It helps to settle the myriad disputes to which human activity gives rise. And it also limits the number of such disputes by enabling us to predict outcomes, by providing some certainty as to the way in which power will be exercised. It enables us to have responsible, stable expectations about the future. It subjects the powerful to the rule of principle, fairly and objectively applied. It promises to satisfy our thirst for formal equality, due process, and justice. So that's the first important introductory point about the rule of law. The second is something that's often forgotten. Indeed, in discourse today, we often lose sight of the fact that there's a very sharp distinction between the existence of the rule of law on the one hand and agreement on law's substance on the other. I say that this is a prominent issue in current discourse that is often simplified, because we sometimes think that if we disagree vehemently with somebody else about what the law is or ought to be, that it's a disagreement about the rule of law. But it's not. It's a disagreement about what the substance and content of particular laws are. It's not a disagreement about the rule of law itself. The real issue is the legitimacy of law as such, not agreements on its content. In fact, that is an extraordinarily important point. Law, if it's legitimate, affords ample room for disagreement about what its content ought to be. To say that law is legitimate is to say that we accept law, we accept its authority, even when we vehemently disagree with its content. But although these points are almost universally accepted, they are widely rejected in practice. First, a relatively small percentage of human beings live under a genuine rule of law. The rule of law is not a binary category. It's a point on a spectrum, or rather it occupies a spectrum, and therefore is a matter of degree. It evolves over time, and discrete areas within the rule of law differ substantively. So, for example, the war of law has a very different content than the law that governs commercial transactions. That's not a denial of the rule of law. That's simply a recognition of the plurality of the content of law under the rule of law. Now, the degree to which the rule of law prevails in the world depends a great deal on whether we include 1.1 billion Indians. India is certainly a robust democracy with many of the ostensible hallmarks of the rule of law. A venerable constitution, statutes, an independent Supreme Court, public interest law, litigation, which has the sanction and the execution of the Supreme Court of India over many years. India has a professional bureaucracy. By developing country standards, the Indian bureaucracy is outstanding, it's distinguished. It reflects a long heritage of respect for administrative justice. India boasts a proud legal tradition guarded by a proud legal profession. There are hundreds of law schools in India. I believe there are almost 1,000 law schools in India that proclaim the centrality of the rule of law. And India has managed, against extraordinary odds, to manage a remarkable diversity, a diversity that is in many respects the greatest in the world, of any country in the world. But my exposure to Indian law and Indian society, much of it instructed by people here at this law school, suggests to me that there are strong reasons to doubt the rule of law's actual domain in India. There are significant violent insurgencies in 1/3 of the country's districts. The vast majority of Indians have little or no access to lawyers or to courts. The reputation of the lower courts is dismal. There are case backlogs in the courts that dwarf anything in Charles Dickens' worst imaginings. It's very easy for foreigners to be beguiled by the formal globalized sector in India. But what happens underneath that sector belies the cosmopolitan and sophisticated domain in which the rule of law prevails. There is immense corruption, probably greater than any of us can imagine, because almost by definition, most corruption is concealed. There are demographic trends that are very worrisome with respect to the rule of law, although their relationship to the rule of law is indirect, but I think nonetheless compelling. I have in mind particularly what I call the dangerous sex ratio. It's not that sex is dangerous, but the sex ratio that prevails in much of India is very dangerous. A much greater percentage of men to women. And there is nothing more dangerous to society than a large population of unmarried men with no prospect of marriage. That bodes quite ill for the rule of law in India. It's also true of other societies as well that practice infanticide and that oppress women and disdain the role of women, China in particular, but many others. Having spoken perhaps ignorantly, but I think accurately, about India's relationship to the rule of law, let me just make some points about the rule of law in the United States. First, our institutions and practices support the rule of law as firmly as in any other society on earth. There is very considerable accessibility to courts by ordinary people. Lawyers are compensated, at least in many sectors of practice, under contingent fee contracts, which enable even poor people to gain access to lawyers if their causes are sufficiently remunerative to attract lawyers in the hope of prevailing. There are small claims courts. There are legal aid societies. There is public interest law and pro bono lawyering activity in